Good afternoon. My name is Larry Ray. I'm the President and CEO of American Manganese, Inc. I'm here to tell you today that American Manganese could possibly bring in the lowest cost electrolytic manganese metal mine in North America. It'll be the first one in the past few decades. What is manganese? Well, you can't have a steel industry without manganese. If you don't have manganese, you don't have steel. If you don't have steel, the world stops. North America has no manganese. We depend on our neighbors and other countries to import our manganese, and it just doesn't make any sense we don't exploit the resources in our own country. So I'm here to tell you that we are moving ahead with the feasibility study, we're moving ahead with the environmental studies, and we're moving ahead with a massive drill program in order to build the American Manganese, Inc. into the first primary electrolytic manganese producer in the United States. Please visit our website at americanmanganeseinc.com or call us at 604-531-9639. Thank you.
Welcome back to the Money and Wealth Show. I'm Sterling Fox, and this week our special guest is bankruptcy trustee Harold Saunders, president of the British Columbia insolvency firm Campbell Saunders, with offices in Vancouver and in Richmond. Harold, just before we took the break, you were talking about the Canada Revenue Agency as being one of those creditors to whom people owe the most money, be it a corporation or an individual. Is the Revenue Department cooperative? Because they have a terrible reputation for chasing you down and running you ragged for a few $100s. As you look back, though, at the big picture, what's their general response in terms of cooperation?
The general response today is that if someone is not a flagrant abuser, someone who hasn't filed tax returns for a long time or is basically deliberately not pay their taxes, they are amenable to look at a viable proposal. And they are tough negotiators. They want the maximum recovery they can receive. But basically, if a proposal is viable and possible, they will look at it. They may require more due diligence. They may want to, because they have so much information themselves on the history of the individual debtor, they may, want certain questions answered. They may have information on assets that we might not have known of, that might have been disposed or not, and they want answers. But once they're satisfied that this person is basically legit and is an honest debtor trying to get out of their problem, right, they will listen. And as I say, they're tough negotiators, but they will. They come around many times. So
they're a lot more willing to work with individuals and corporations than perhaps their reputation suggests they are.
At least with us, in our experience with CRA, they've, as I say, they're not an easy pushover. But if the facts are there, everyone's done their due diligence, they'll look at it. And again, they look at the history of the individual to determine whether they should, given a chance to do a proposal.
I wanted to ask you about corporate bankruptcies. Some individuals and people in business seem to think of it in rather cavalier fashion. Oh, we'll start up this enterprise, we'll get it going, and, we'll give it our best shot. But, if it fails, what the heck, we'll go bankrupt and start all over again. As if, it's just like flipping a page in a book. And is that the case? Is it that easy for a business to fold, go bankrupt, turn around, and start back up again?
Well, depending. If it's a proprietorship or partnership, obviously it's the individuals ultimately who are going bankrupt, and their credit rating is affected. If it's a corporation, you have the directors of that corporation could be liable, for example, unpaid payroll deductions, unpaid GST. There could be guarantees to various creditors, such as a landlord. So it's not so easy to say just close her down, we'll start again.
But you've heard that in the past, haven't you?
I've heard it, And look, there's always the incorrigibles, no matter what. You always have people who are going bankrupt who don't care. And maybe there are business people who don't care. But it's tough to get going again. So you got to think very carefully. And many businesses need to do restructuring. As long as they can get, especially if they have secure creditors involved, get them on side.
Yeah.
And then make a rational or reasonable offer to the unsecured creditors.
If the consumer proposal, as you've described it, which is a step shy of bankruptcy, but still a legal requirement once you enter into it, what then is the legal gap between a consumer proposal where you're satisfied, your creditors are satisfied that, sure, you've got a payment plan and now you're going to deal with it and the law is keeping an eye on you? What's the difference between that and actual bankruptcy?
Well, a consumer proposal is an arrangement between a debtor and their creditors.
Okay.
As long as it's accepted, and there is a process that you have to go through, as long as it's accepted by the creditors, and you comply with the terms of that proposal, which can be varied in different ways, and you don't default, and there's rules of default, basically and you get a certificate of full performance. Basically, you've complied with the terms of the proposal. It's on your credit record for 3 years after full performance. But you continue with your life, you can continue in business. You're a debtor in possession, basically. You're not bankrupt. Certain rules of bankruptcy do not apply.
And what are the rules that make the difference from a bankruptcy perspective, Harold?
Well, an individual, when they go bankrupt, their assets basically vest or belong to the trustee subject to certain exemptions. For example, in British Columbia, there's a Court Order Enforcement Act where you can basically, that protects furniture and appliances up to a certain level, your clothing, tools to earn a living, vehicles up to a certain limit in value. So RSPs are now protected in legislation based unless contributions were made to it within the last 12 months. Certain life insured contracts are protected. So, but you have obligations that you must comply with during the term where you're an undischarged bankrupt.
Okay.
And basically a bankruptcy will go, unless there's a special application to court, for at least 9 months, and it may continue beyond that. But you have duties that you have to comply with where it is in a proposal. Once it's approved by the creditors and the court, it's a deemed court contract, you don't have to go through that.
Interesting stuff. Our guest is trustee in bankruptcy, Harold Saunders. We're going to talk about that stain on the reputation. You mentioned credit record a moment ago, and as we continue our look at the dark side of money and wealth, we'll find out that and lots more. Do stay with us here on the Money and Wealth Show.
Good afternoon. My name is Larry Ray. I'm the president and CEO of Gold Ray Resources Corp., a company that trades on the TSX Venture Exchange and has the majority of its operations in China. We are currently developing a resource there with limited production at this time. Our goal is to increase this production up to about 1,200 to 1,500 tons per day. And to do that, we are negotiating with several Chinese companies, one of which will become our partner either directly into the company or into the project, which will allow us to move the project up to the desired tonnage. For further information, please visit our website at goldray.com or phone 604-531-9639.